Hi, now we saw in another video that Brexit definitely did not kill GDPR. In fact, it split GDPR into two, the UK GDPR and the EU GDPR. And as just one practical difference, we saw how this multiplies your potential liability for huge fines in cases of breach. We'll cover this and other practical privacy aspects from Brexit in this free video. So sit back, grab a cup of coffee and stay with us, because at the end I'll share a bonus tip that'll help you win business in 2021 and beyond, and help you put in place measures to take care of Brexit. Hi, I'm Robert Bohr, the founder and CEO of Keepable, the award-winning solution saving you time, money and stress on GDPR, giving you a great answer for the board and customers. This video is part of Privacy Kitchen, free video help on GDPR and all things privacy. If you're new here, please do click subscribe and notify to hear about our awesome Privacy Kitchen videos. So, what does Brexit mean for your privacy program? Well, the easy part, nothing changes until the end of 2020. Now, we saw in our video, Did Brexit Kill GDPR, that EU GDPR will no longer be direct law in the UK from 1st Jan 2021, but until there's a European adequacy decision in favour of the UK has to continue applying it to personal data that has been transferred to UK entities from the EEA before the end of 2020. We call this EEA legacy data. The government calls it stock data, but we think EEA legacy data is a bit clearer. We also saw that the UK has already enacted laws to create a twin UK GDPR as from 1st Jan 2021, and that those changes are almost literally limited to replacing the EU with the UK and removing references to EU oversight. But what's this mean to you? Well, if you're a UK organisation, you absolutely haven't interacted with Europe in any way and aren't going to interact with Europe in any way, it may well be you're just going to be covered by the UK GDPR. But if you have been dealing with Europe, or you continue to deal with Europe, maybe you've got a subsidiary there, you sell to individuals there, you monitor individuals there, then there's a very good chance you're going to be subject to both the UK GDPR and the EU GDPR. And for people who are outside the UK and the EEA anyway, so for example the USA, you're going to have to look at the two territories separately, EEA and the UK, and you're going to have to comply with both GDPRs potentially. Okay, now for the practical effects of having the two laws, and the first one is the potentially massive multiplication of regulatory risk, or fines. This is something UK Limited's boards of directors should be very worried about. The UK GDPR's fine structure is identical to the EU GDPR's, with the €20 million part replaced with 17.5 million. That 4% of global turnover, if higher, still is there. You still need to record all breaches, and you still need to notify certain breaches to the UK ICO and certain ones to the individual. But because of Brexit, and unless there's a new agreement put in place, the UK can't make use of consistency mechanisms, one-stop shop, etc. So these are the mechanisms that mean if you have a breach affecting several countries in the EEA, one country's regulator will take point and investigate it and fine on behalf of everybody else. Unless an agreement comes in place otherwise, if you have a data breach in 2021 and beyond, you may well have to notify all of those EEA regulators and be subject to investigations by all of them and potentially fines from each of them, as well as a fine and investigation from the UK ICO. Now let's not run away with the fear, but let's recognise that that risk is there and stick around for the bonus tip to help address this. So the second big practical difference or group of differences is around transfers. So a transfer is when personal data goes outside or is accessed from outside the jurisdiction of the law. Now, the jurisdiction of the law for the EU GDPR is the EEA. The jurisdiction of the law for the UK GDPR is the UK. You'll still deal with transfers in the same way. In practice, that's adequacy decisions first, and if not, standard contractual clauses. But the jurisdiction and the geographic area has changed. And there are two main impacts. First, when you transfer personal data outside the UK to a processor or another controller, you'll need to identify the safeguard for that transfer, like the standard contractual clauses and adequacy decision, but under the UK GDPR. If you have to comply with the EU GDPR, you'll be looking at that for transfers out of Europe. So you'll need to record these adequacy decisions or have these standard contractual clauses in place for potentially both GDPRs, depending on where you're exporting the data from. From 1st Jan 2021, the UK essentially just takes everything from the EU GDPR, so we can rely on all those adequacy decisions, we can use the EU standard contractual clauses, so you don't need to make any changes to what you've already got in place now. Now you'll need to record these transfers outside the UK correctly in your Article 30 records for UK GDPR. If you're also transferring outside of the EEA, you'll have an Article 30 records for the EU GDPR, so you'll have two slightly different sets of the same type of record. Now, the next group of practical effects is all about people. Each organisation will need to review whether they need a DPO, a data protection officer, under the UK GDPR, and a UK representative. Now, EU GDPR has the requirement for a DPO in certain circumstances and an EU representative in certain circumstances. The rules are identical, so do have a look at do I need a DPO and who can be DPO videos there. They equally comply. But what this does mean is some organisations will be doubling up. And last but by no means least, you're going to have to review all of your privacy documentation and documents that touch privacy, from privacy policies to DPIAs, data processing, impact assessments, your processing agreements, joint controller arrangements, etc. And you'll need to see how these need changing to take account of these two almost identical but different laws. It may be a reference change in some, maybe more in others. And you'll have to do all of this taking into account if you've got any EEA legacy data to which the EU GDPR still applies until there's an adequacy decision. And now that bonus tip, and it sounds again like we could do with one, so we've got a few again. First, make sure your privacy governance is principles based. Your privacy framework, everything you do reflects the principles in the EU GDPR. It's going to be identical in the UK GDPR. That way, all of your policies, all your procedures, your training, awareness, reporting structure, everything you're looking out for will be applicable to both, with a few tweaks on the procedures that are impacted. Now, if you're in the UK and have EEA customers, do prepare for no adequacy decision by the end of 2020. It's quite simple. Have the EU standard contractual clauses ready to go as of 1st of Jan 2021. They're easy to put in place. You can't actually negotiate them. You just fill in the blanks and describe your security. Now, obviously, you have to comply with them, which I'm assuming you do because the GDPR already applies here. And it will mean the EU GDPR effectively is ported with the data that you receive and applies to your processing of that data. Next is to make those SCCs part of the same document as your general processing agreement into a nice complete data processing addendum. And if you have one or more EEA establishments, and that is defined very broadly, we'll look at that too, do consider making one of them the controller of personal data for data subjects in the EEA. This cannot be lip service. It does mean they're meant to be in the driving seat for determining the purpose and means of processing EEA personal data. But if you can do it, it means your UK presence should be largely ring-fenced from that risk of multiple fines that we talked about, because that EEA establishment will be your main actor in Europe and will be able to benefit from the one-stop shop and consistency mechanisms we've discussed. So there you go, a quick run through Brexit and GDPR and what it means for your privacy compliance practice. It's more important than ever to have principles-based governance in place. Please do look at our other videos, such as Did Brexit Kill GDPR? And Do I Need a DPO? Who Can Be DPO? These are equally applicable under UK GDPR and EU GDPR. Please do visit us at keepable.com, see how we can save you time, money and stress on GDPR, and do use #PrivacyKitchen to let us know other topics and questions you want covered. Stay well in the meantime, and I look forward to seeing you in Privacy Kitchen soon.